We break down 3 separate probable cause hearings presided over by Judge David Fletcher of the Harris County Criminal Court in Houston, Texas. A probable cause hearing happens shortly after an arrest, especially when that arrest was made without a warrant. Under Article 17 of the Texas Code of Criminal Procedure, the arrested person must be brought before a judge without unnecessary delay. At that appearance, the judge advises the defendant of their rights and reviews the evidence presented by law enforcement to determine whether there was lawful reason to make the arrest. If the judge finds no probable cause, the defendant must be released. Our first hearing occurred on November 4th, 2024, following the arrest of Raquel Rodriguez, who was charged with driving while intoxicated on October 28th, 2024.
Okay, Max, who do you have here?
Raquel Rodriguez.
Vic, you ready? Okay, this is page 20.
Rodriguez on page 25.
All right, Ms. Rodriguez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and/or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Yes, Judge.
Okay.
The officer initiated a traffic stop after observing the defendant's vehicle traveling 94 miles per hour in a 65 mile per hour zone. The officer observed an odor of an alcoholic beverage, and the defendant admitted to the officer that she had 2 drinks. Standard field sobriety tests were conducted, HGN 4 out of 6, walk and turns 5 out of 8, one leg stand 2 out of 4. The DIC was read and breath was refused. A blood search warrant was signed and executed.
Felt like that went really fast. So the stop was for speeding.
For speeding, yes.
Then,
And then after that, they had an odor of an alcoholic beverage, and she made an admission that she drank 2 beverages.
just an odor and admission of 2 beers. Any other indication of intoxication? I mean, slurred speech, bloodshot eyes.
I know that while the SFSTs were, this is for the Jams, while the SFSTs were being conducted, she was not understanding, like the officer had to explain, I think at least 4 times, the instructions for the walk and turn, the one leg stand. He also noticed that I think she took off her boots for the one leg stand. She was stumbling when she was taking them off. So there were other signs that the officer.
That's what I want. I mean, just an odor, not even a strong odor at that, you know? And then you just have an admission of 2 beers. You don't know what time. Was it over a 12-hour span? You know, there's no accent here. There's no... is she a Spanish speaker?
I believe so, Your Honor.
I don't see any indication of that.
And if I may, I've been doing DWIs for 10 years and I don't understand the instructions most of the time.
As far as I can tell, the officer also just demonstrated it to her. I mean, which is per, you know,
But I
procedure for
get the
SFSTs.
SFSTs, but I mean, to even get to the SFSTs, right? You have to show something that there's some indicia of intoxication. Here, all we have is an odor and admission of 2 beers. That's not enough. An odor of alcohol in and of itself is insufficient.
Yeah.
It seems that this stop occurred at 2 in the morning, and she made a statement that she stopped drinking at 12 a.m. So we have a 2-hour period when she's finished drinking, and then
Alcohol dissipates every 1 hour. An alcoholic drink dissipates from your system.
she still had the odor in addition to that statement.
All right, I'm going to find no probable cause.
Yes, Judge.
Thanks, sir.
Ma'am, be careful, you know, really. Every single day, someone dies from a DWI in our county. It's so easy to take a $20 Uber, literally push one button, you have a car waiting for you wherever you want to go in this county. Do you understand?
Yes, sir.
Right, please take a seat.
Judge Fleer found no probable cause for the charge after determining that the evidence did not establish sufficient indicia of intoxication to justify administering standardized field sobriety tests, SFSDs. Because SFSDs prolong a traffic stop and create a more extensive investigative detention, officers must have reasonable suspicion that a driver has committed an intoxication offense before they can require these tests. In this case, the only evidence presented was the odor of alcohol and Ms. Rodriguez's admission that she had consumed 2 drinks, the last one approximately 2 hours before driving. Based on these facts, Judge Fleer concluded that there was no reasonable suspicion to extend the stop for field sobriety testing under state and federal case law, as well as Article 38, 23 of the Texas Code of Criminal Procedure. Under that statute, any evidence obtained through a constitutional violation, such as prolonging a traffic stop without reasonable suspicion, is inadmissible in a criminal case, because the field sobriety test results could not legally be considered. Judge Fleer held that probable cause for the arrest was lacking. The state later dismissed the charge on February 24, 2025. The next probable cause hearing we review also took place on November 4, 2024. In that case, defendant Kean Shaw had been charged on October 28, 2024, with fleeing a police officer in violation of Section 545, 421 of the Texas Transportation Code, which makes it a misdemeanor for a driver to willfully fail or refuse to stop when given a visual or audible signal by a pursuing police vehicle.
You are Keon Shaw.
Yes, sir.
Mr. Shaw, you're charged with fleeing a police officer. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On October 27, 2024, officer was conducting a routine patrol on Eldridge Parkway when he noticed the defendant's motor vehicle traveling at an unsafe speed, exceeding the posted 35-mile-per-hour zone. The vehicle then began driving in a suspicious manner by making a sudden left turn on the street and immediately parking on the left side of the road. When the vehicle noticed the officer's fully marked patrol vehicle passing, it immediately conducted a U-turn and got back on the main road. When officer continued to follow the defendant's vehicle, the vehicle again conducted a left turn and pulled into an alleyway. When the officer initiated his emergency equipment in an attempt to conduct a traffic stop, the defendant's motor vehicle passed multiple safe stopping points before finally coming to a stop after traveling 0.5 miles through a dark and empty parking lot.
What was he doing wrong?
According to the officer, he was originally traveling at an unsafe speed, exceeding the speed limit, 35 miles. He was exceeding that speed limit.
By how much?
Let me see the DMs if he specified. Your Honor, he did not specify. It was just an unsafe speed exceeding the limit. And then
Nothing's unsafe to me.
And then he began driving, according to the officer, in a suspicious manner, making sudden turns and then stopping on the side of the road and then getting back on the road once the officer passed. So,
Anything illegal with that? You know?
I believe it would just be the speed limit would be the point at which the officer.
It's a conclusory statement. We need to have like a workshop on how to write ORs, man. For real. You know, everything in this office report is conclusory, suspicious, aloysius. You know, is he driving while black?
Judge, would you allow us just a few minutes to call the officer just to see? We don't have an OR. We're just going off of the
Sure.
terms.
Let's do this. I'm going to have him because I want to make sure if we find probable cause that it's really there. All right. So just hang tight for me. We're going to have to do a little deeper dive. If you just mind taking a seat for me momentarily. Okay. Okay. Okay, so Mr. Shaw, we're back on you. So just because we do so much, I tend to forget everything, you know. You're charged with fleeing a police officer. You're facing up to 6 months in jail and a $2,000 fine. We left off because we were doing probable cause, and I had an issue because it seemed like the cause was kind of conclusory at the time. And do you have anything new?
No, Judge, and I agree with the court.
So, okay, I'm going to find no probable cause.
Dismissing the case.
Find no probable cause. Be careful when you're out there. It's hard enough as it is. Don't give anyone else the power to even bring more, trouble on your life, all right?
Yes, sir.
All right, man. Good luck.
Judge Fleer found no probable cause in this case because the officer failed to provide a specific allegation regarding the driver's speed, information necessary to justify the initial traffic stop. While the Texas Transportation Code does not explicitly require a lawful stop to sustain a fleeing charge, constitutional protections still apply. If the stop violated the Fourth Amendment or Texas law, then, as noted earlier, Article 38, 23 of the Texas Code of Criminal Procedure prohibits the admission of any evidence obtained as a result, including the officer's account of the driver failing to stop. Under the Fourth Amendment, an officer cannot detain a vehicle without reasonable suspicion based on specific, articulable facts indicating that a traffic offense or other crime has occurred. In the 2005 case Ford v. State, the Texas Court of Criminal Appeals held that an officer's bare assertion that a driver was following too closely, without describing the actual distance, was insufficient to establish reasonable suspicion. The court emphasized that conclusory statements are not enough. Applying this principle, Judge Fleer determined that the officer had not provided sufficiently specific and articulable facts to support reasonable suspicion. As a result, there was no probable cause based on the admissible evidence, and the state dismissed the charge that same day. The final probable cause hearing in today's episode occurred on January 27, 2025. Defendant Francisco Cerda was charged on January 22, 2025, with engaging in organized criminal activity under Section 71(02) of the Texas Penal Code. This statute makes it a crime to commit, or conspire to commit, certain offenses with the intent to establish, maintain, or participate in a combination, defined under Section 71(01) as 3 or more individuals collaborating to carry out criminal activities. The statute applies broadly to offenses such as drug trafficking, robbery, burglary, assault, murder, money laundering, and, as in Mr. Cerda's case, theft.
Last one, Your Honor, is Mr. Francisco Cerda. He's a custody judge, and I wonder if I'm wrong on this.
Is that C or an S?
The C judge,
Good morning, Mr. Cerda. You were charged with engaging in organized criminal activity. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 21st, 2025, the officer was dispatched to a residence in Harris County, Texas. In the call notes from dispatch state, the reportee says an unknown party stole her neighbor's U-Haul trailer. Subjects were seen headed towards Pasadena Boulevard. The driver was a skinny, tall male, and the reportee lives on Buchanan Street and has camera footage of it happening. A witness stated he observed individuals taking the neighbor's U-Haul. The officers located the U-Haul and a felony stop was conducted. Defendant Hentoja was observed unloading items from the U-Haul, ran to the back of the residence, and prevented officers from arresting him. Defendants Lopez and Cerda remained in the U-Haul, and the complainant stated the value of the trailer was $1,800 and dirt on the trailer was $300.
I have so many questions.
Yes, Judge.
I don't even know where to start.
Judge, that's my concern. If you may, I want to bring some, some points of argument to the court's attention. The first one, my concern is that, the 911 caller mentioned unknown parties, and then the police officer later mentions the messed up things without any type of articulable facts, believe that they are the specific people, that are the individuals that have taken this U-Haul. Now, as we know, probable cause requires more than a hunch, more than suspicion. It requires something else, more than that. And that seems that that's all that the things, at least under the four corners of the things, allege that my client was involved with this alleged theft.
Remember, so when they start an investigation, sometimes they just don't have everything, and facts develop in time.
Right.
Here, we have a call that several people have stolen a U-Haul.
Yes, Judge.
And they've given a description of a tall, lanky person, right?
Yes, Judge. And respectfully, we defer to the court because all it says in the DIMS is that the defendant Cerda remained in the U-Haul. There's no further information regarding Cerda.
Where was he in the U-Haul? Was he in the actual U-Haul? Was he in the truck that was driving the U-Haul? How was he engaged in this alleged criminality?
And Your Honor,
can you does mere presence impute criminality?
Judge, and that's exactly right. Texas law says that mere presence is not enough.
Dude, I'm with you.
Okay, yes, sir.
But so
we're not arguing against that, Your Honor. And like I said, we defer to the court because we don't have that information. We'd have to await the OR, and we don't have that at this time.
But I'm not going to sit here and hold someone.
And that's why we defer to the court.
Let's look at what the statute says, because 7102. A person commits an offense if, with intent to establish, maintain, or participate in any combination or in the profits of a combination, or as a member of a criminal street gang, the person commits or conspires to commit one or more of the following. 1 is murder, capital murder, arson, yada, yada, yada. 2, any gambling offense punishable by a Class A misdemeanor. Promotion of prostitution. Number 4, unlawful manufacture, temptation, firearms. Which one are you relying on?
Your Honor, as is pled, is that it's pled as theft as being the underlying basis of the engaging in criminal activity. And right now, Kelsey is looking at the case. We may very well dismiss this because of the insufficient evidence in the information in the DIMS, but right now, Chief is looking at it.
And Your Honor, we could just maybe reset it for a week or so, we call the witness. And we have to decide.
He's in custody, and I can't, if he was on bond, that would be one thing, but he's in custody. I'm not going to hold him just because, compounding it, Casey, is that he's got an ice hold, so I can't give him a PR bond,
I would just need, I just need a little more time, Your Honor, to dismiss it right now.
Yeah, I'll find no PC because I just don't think it's there for now. And then if you find something later on, by all means, but all right, Mr. Sird, I'm going to find that there's no probable cause to go forward in your case. Just, Mr. Serta, be careful who you hang out with, Okay. All right, for sure.
Judge Fleer found no probable cause in Mr. Serta's case because there were no specific allegations regarding his conduct beyond merely being present inside the stolen U-Haul. As the Amarillo Court of Appeals explained in the 2000 case Munoz v. State, a conviction for engaging in organized criminal activity requires proof that the defendant intended to participate in, maintain, or establish a group that agreed to work together in a continuing course of criminal conduct. Conduct that spans more than a single criminal episode. The court further held that simply being present during one instance of criminal activity does not establish an agreement to engage in ongoing illegal activity. In Mr. Serta's situation, the only allegation was that he was inside the stolen U-Haul. There was no evidence suggesting his involvement in more than one criminal episode, nor was there proof that the 3 individuals linked to the case had formed an agreement to operate as a continuing criminal enterprise. As a result, Judge Fleer determined that probable cause was lacking, and the state dismissed the charge on February 24, 2025. These hearings highlight why probable cause determinations serve as a crucial safeguard in our justice system. When someone is arrested without a warrant, their freedom is taken immediately, often based solely on an officer's version of events. The probable cause hearing provides the first real opportunity to test whether that arrest is supported by evidence strong enough to survive judicial scrutiny. Judges like Judge Fleer, who rigorously examine the facts instead of rubber-stamping arrests, help ensure that constitutional rights remain meaningful and that government power is properly checked. When a judge finds that an arrest lacked probable cause, it not only protects the accused, but also reinforces public confidence in the court's commitment to fairness and impartiality. If there's a case or courtroom moment you'd like us to cover next, let us know in the comments. Thank you for watching, and don't forget to subscribe and share to help foster a more informed public.